Welcome to the fifth presentation in this season's UBC Okanagan Distinguished Speaker Series. And I'm very pleased to open tonight's presentation with a few remarks about the series itself. UBC Okanagan has been able to present a range of outstanding speakers thanks to the vision and generosity of Irving Barber. His commitment to post-secondary education in British Columbia included a substantial gift to UBC Okanagan, establishing the Irving K. Barber School of Arts and Sciences Endowment. And that fund is used to enrich learning for our students and to engage the community through initiatives such as the Distinguished Speaker Series, which we're part of tonight. We are fortunate to have deeply committed and visionary people involved in what we do here at UBC Okanagan. Our first presenter tonight is definitely one of these very engaged innovators at our university. Professor Carl Hodge is expanding the educational horizons of our political science students in unique new ways. For example, he has arranged classes tailored for students who are interested in pursuing law school after graduating from UBC Okanagan. Professor Hodge and the Canadian Contemporary Law Concentration have found extraordinary support from the Okanagan's legal community. And it's through this support that we are able tonight to present Canada's Chief Justice. To tell you a bit more about this, let me introduce Carl Hodge, and then in keeping with the situation, we will have a series of introductions for the Chief Justice. Carl?
Good evening. I should probably tell you how this all came about by way of giving you a story. This all started about a year ago, maybe a little less than a year ago, when the head of my unit at UBCO, Piotr Brezhnevsky, phoned me up and said that Dean Bauer, that is Dean Bernie Bauer, had an idea. And I thought to myself, I hate it when deans have ideas. And the idea was that we all get together and meet at the home of this man named Wally Lightbody, who I must confess I've never heard of. And the idea was for a law concentration of courses at UBCO. And I thought to myself, somebody here thinks I know something about law, and I don't, and that's ominous. So maybe I should just go and tell them that I know nothing and have nothing to offer. And it turns out to be, though, the reason I'm telling you this story is that Wally Lightbody had a great deal to offer. And as I was to understand, we went around to his home, all three of us, one afternoon, and Wally and Marietta set us down to coffee and biscuits. And Wally outlined his vision of having a law concentration of courses at UBCO, and would I be the coordinator for an inaugural course? And in the presence of Wally and Dean Bauer and my unit head, I couldn't very well say no, not interested. Wally also assured me, though, that this would be easy to do, that I would have input from the local legal community, that they were all very, very interested and very, very enthusiastic. And he said that, well, they're like academics, Carl. They like to talk, with the difference is that they actually show up on time. And that has turned out to be true. They're incredibly punctual. I think it has to do with having to go to court. In any event, they've been extraordinary. But and Wally was the visionary for this. And sometime last fall, Wally assured me that he could get me a couple of high-profile speakers, and he thought it would be a good idea to kick off high-profile speakers in the law program with the Chief Justice of the Supreme Court of Canada. And I wasn't going to argue with him, and he assured me that he could get the Chief Justice, and I thought of assuring him that I could get the Pope. And we take it from there. But sometime last November, Wally phoned me up and told me he had the Chief Justice, at which point my attention was riveted. The reason I'm telling you this is because this course and this community owe a good deal to its local practicing legal professionals, for the most part because of Wally Lightbody, a retired legal professional who has, well, never truly retired, and has a vision for the future of law at UBCO. Someday we are, Wally, going to have a law school, and this is a start. Having done that, I want to introduce Wally so that he can explain to you how this evening all came about. Wally, would you join us out here?
Thank you, Carl, for all those kind remarks. I must say that it's been a great pleasure to have been working with Carl and Bernie Bauer and the rest of the people at UBCO, because they're just splendid people to work with. And, you know, having established this UBCO, University of British Columbia in the Okanagan, I tell you, I was at a lunch in Vancouver the other day and had sat with some old colleagues of mine, and I started telling them what was going on here in the Okanagan, in Kelowna at UBCO, and they just kept shaking their heads. They couldn't believe that, you know, we had like 5,000 students here and a 200-odd faculty, and the building that was going on with the residences. And I tell you, it's a fantastic. If you haven't been out there to have a look and a tour around you should do that. Make a point of doing it. But it's just been my delight to have been involved in this, and I'm going to tell you that it's my delight and my honor to be able to introduce to you the Chief Justice of the Supreme Court of Canada, the Honorable Beverley McLachlin. Before I do that, I want to say that I think that Carl talked about the seeds that we put together in order to get this scholarship funded. The Okanagan Bar came forward, and we raised $50,000 there, and then we got a matching grant from the Law Foundation, and on it goes. And I got a very endearing letter from a student who went graduated from UBCO here and is now attending law school in Vancouver and received the first of those scholarships. And you know, it was such a great letter, and he was so grateful for having received that. But that's the way it's going, and it's continuing on. I want to tell you that it will even expand as time goes on. Whether we'll have a law school here as time goes on, that's a question that we'll have to deal with in the future. But as I say, it's my pleasure to introduce to you the Chief Justice. We all know that she is the first female Chief Justice in Canada, but more importantly, she has risen to this position not because of her gender, but because of her superb intelligence and legal qualities of diligence and dedication. These attributes served her well in law school in the University of Alberta, where she graduated at the head of her class. She practiced law from 1969 until 1975. From 1974 until 1981, she was an associate professor and professor with tenure at the University of British Columbia. From there, she embarked on her impressive career as a jurist. In 1981, appointed to the County Court of Vancouver, then to the Supreme Court of BC, next to the Court of Appeal, and in 1988, Chief Justice of the Supreme Court of BC. She was appointed to the Supreme Court of Canada in 1989 and made Chief Justice in 2000. I'm going to refer to just one of her judgments, well-reasoned and wise in the knowledge and experience of the social values and mores in a free and democratic society. It became necessary for the court to consider the constitutionality of the provision of the Criminal Code dealing with child pornography as opposed to the right to freedom of expression as guaranteed in the Charter of Rights and Freedoms. The case was Regina versus Sharp, which a lot of you, I'm sure, have heard of and read about. In any event, the Chief Justice, in delivering the majority of the judgment of the court, held that Parliament was pursuing the pressing and substantial objective of criminalizing the possession of child pornography that poses a reasonable risk of harm to children. The means chosen by Parliament are rationally connected to this objective. In short, the Chief Justice held that the provisions in the Criminal Code prohibiting child pornography remain intact. I'm indeed proud of the members of the Bar, and more particularly the Okanagan Bar, in contributing to the endowment that I mentioned earlier. We've established at UBCO for worthy graduates who have been accepted into the UBC Faculty of Law, and those members of the Bar who, under the capable leadership of Professor Carl Hodge, are donating their time to teach aspects of contemporary Canadian law in the Barber School of Arts and Science. It is indeed fitting that we should have as our first distinguished speaker in this program the most distinguished jurist in Canada. She has been awarded over 21 Doctor of Laws degrees. One particular honor I will mention because I was instrumental in establishing it, and that is the Anthony Pantages QC Medal presented yearly by the Justice Institute of BC to an individual who has made an outstanding contribution to the administration of justice. Our guest of honor received that award in 2003. Ladies and gentlemen, please help me to welcome to the podium the Honorable Beverley McLachlin, Chief Justice of the Supreme Court of Canada. Beverley.
Thank you. Good evening, bonsoir. It's a great pleasure to be with you here in Kelowna tonight and to be with so many members of the university and the community. As you might expect, I'm a great believer in the law and the rule of law, but I'm also a believer that the law should engage not only jurists and lawyers and the litigants who find themselves involved in its workings, but the law should engage the community. The law is an important and foundational institution of our community and our values. The purpose of the law and of our courts is to serve the public, and we will only succeed in this goal if we hear and understand the needs of the public, and if we enjoy public confidence in justice and the courts. So it's a great pleasure to be here tonight to share with you some of my thoughts on one aspect of the justice system, access to justice. And later on in the evening, I hope to hear from you, because as a judge, I need to listen as well. I need to know what members of the community are telling us about their system of justice. Tonight, as has been announced, I'm going to say a few words on access to justice. I believe that access to justice is a basic public right, the right of every man, woman, and child. And I am convinced, unfortunately, that this right is not always fully met. My comments tonight will fall into two parts. First, the problem, and then what the solutions might be. The problem, briefly put, is a disconnect between the ideal of the right of every person to have justice done in his or her case, whatever it might be, to have access to lawyers that they need, the courts they may need, and the reality that many people, for one reason or another, are unable or choose not to access the justice system and are hence denied justice. The solution, I will suggest, is a concerted and united effort to bridge the disconnect between the ideal of the right to justice and the reality, too often, of justice denied. Let's look more closely at the problem. Let me begin by asking a fundamental question. Is it a problem? Is it a problem if people can't access the justice system? It may be, certainly, for those people. But is it a problem that we in society, more broadly, should care about? In short, is justice a basic right, like food, shelter, or adequate medical care, that a civilized society should provide to all of its members? Or is it a luxury, like a Ferrari car or a Dior dress, available to those who can afford it, but denied to those who cannot? Well, you might reply, of course justice is a basic right, perhaps the most basic right. But we should not take it for granted. In some places, the view has been gaining ground that justice, apart from basic criminal law procedures, is really a service that the state and the profession provide, and as such, it's a service that should be paid for directly by the people who use it, underwriting it completely financially. For example, in the United Kingdom, rules have been introduced in the civil side, in the civil courts, to introduce a self-financing regime where operating costs are largely covered by user fees. Well, it sounded like a good idea, but people in the United Kingdom are starting to question it. What happened was that there was a 2,500% increase in court costs. This, in turn, led to a lot of people saying, I can't use this system, or I choose not to use this system. So the number of users declined by up to about 25%. And as a subsequent consequence, the amount of revenue taken in by the court system declined. So it seemed as though they were being caught in some sort of vicious cycle, which resulted in canceled court sittings, delays, and so on. Now, this was a bold experiment, and some are now beginning to ask questions. A recent headline in a British newspaper proclaimed this: self-financing legal cases are too high a price for society. Getting back to my point that justice is a basic commodity of importance for all society. It's my view that justice is a basic good to which every member of society is entitled. Everybody should have access when they really need it. I believe this view to be supported by history, by the need for stability in our society, and by what it means to be a human being possessed of human dignity. Let me just briefly extrapolate on those three things. Historically, we are told that when Henry II in the 1300s set out to bring the wild tribes of Britain under some sort of civilized control, one of his first steps was to establish a justice system. He organized what were, and sometimes we still call them that, assizes. The king's judges would be sent out to all the towns of the land to hear the people's claims and to try those accused of offenses. In a word, to establish the rule of law and do justice. The service was free and readily accessible. No doubt it was also primitive by our standards, but the ideal of public justice for everyone was planted. It has stood the test of time. We should not lightly forfeit it to concerns of cost or the current fashion of privatization. Historically, justice has been treated as a public good, and I believe it should so remain. Public justice also promotes stability in society. People settle their grievances, if you have a good justice system, not by throwing brickbats or slanders or vigilante action, but in court. An accessible justice system is the hallmark of a stable, peaceful society. It brings security. An accessible justice system also promotes social equality. To make justice a pay-as-you-go luxury is to create two classes of citizens, those who can access the courts and those who cannot. Finally, justice, fair treatment by another name, is a good every human being seeks. Read our great literature. Talk to psychiatrists and physicians. Our brains are hardwired for justice. To be required to accept that one cannot have justice for whatever reason is to be required to sacrifice an essential part of oneself, indeed one's human dignity. a right enshrined in the United Nations Declaration of Human Rights, to which Canada subscribes. These reasons, history, social peace, and individual fulfillment, support the view, I would contend, that justice is a public good that should be available to all. Every individual should have access to justice. The most advanced justice system in the world is a failure if it does not provide justice to the people it is meant to serve. Well, the next question then, if you accept that, is whether in Canada people are able to obtain this basic good that we call justice. I'm happy to say that for many people the answer is yes. We have a justice system that is the envy of many people in the world. But the fact remains that it does leave some people behind. It does, for one reason or other, effectively shut certain people out. And that is a problem I believe we should address. In my travels across this country as Chief Justice, I hear stories of people who have legal problems but do not know where to turn for help or whether they can afford a lawyer. These problems may start out as defined legal issues. A tenant is being evicted from her apartment without notice. A spouse is trying to achieve a just settlement in a failed marriage. But if these particular problems are not resolved, they can turn into bigger problems. Without legal help, people may face months, if not years, of personal difficulty as they attempt to navigate the sometimes complex demands of law and procedure. This can lead not only to lack of closure, being able to turn the page, but to frustration and ultimately loss of confidence in the justice system. And sometimes people just give up entirely and nurse their grievance to the end of their days. What these people are telling me is that they have been denied access to the justice system and hence to justice. Now let me be quick to say that we have our success stories. As I said a moment ago, by international standards, Canada's system of justice ranks with the best. The well-off have no difficulty obtaining excellent legal help and pursuing their claims to a fair conclusion. The same goes for many commercial actors, although in places, cracks may be starting to show, as we hear complaints that courts are sometimes too slow or expensive to provide practical solutions for dispute resolution in the commercial sector. Finally, in most provinces, and this is good news, people charged with serious crimes where their liberty is at stake receive legal aid, permitting them an adequate defense. The process is sometimes slow and costly, about which I'll speak more later, but basic help is provided. So people have worked very, very hard to establish these successes, and we should be proud of them. But we should also be aware of what remains to be done. The women, men, and children from thousands of middle-class families caught up in the throes of family breakup each year. The thousands of people facing regulatory problems, ranging from disputes with a landlord to tax disputes. The thousands of people who can't afford to sue the perpetrator of a personal injury, or a person who has failed to meet a contractual obligation on a house renovation. The thousands who don't have wills simply because they haven't thought about it or can't afford it. These are people who are struggling or should be struggling to access our justice system, and they are considerable. The result is clear, it seems to me. For too many people, there is a profound disconnect between the expectation of justice as a basic good, like medical care, basic shelter, and the reality that sometimes justice is out of their reach, or at least seems out of their reach. And seeming out of their reach can make it just as elusive as if it actually is, because if people believe they can't get help, they won't seek it. One symptom of this problem is the increasing number of unrepresented litigants, that is, litigants who appear in person without a lawyer, in Canadian courts. Although it's difficult to produce exact statistics, some courts report that more than 44% of cases involve self-represented litigants. There are many reasons for this. Some people may just feel that with access to the internet and Judge Judy, they can go in there and do their own job. But the cost and delay involved in the legal system also figure. In 2005, the Alberta Law Reform Institute found that the increased presence of self-represented litigants is due to, and I quote, an increase in the number of persons who are unable to afford a lawyer because of rising court and lawyer fees, the costs of prolonged litigation, cutbacks in funding for legal aid, and tightened restrictions on eligibility, end of quote. In other words, for many people, the cost of a lawyer is out of reach, and complex legal procedures and delays are denying people real access to justice. Self-represented litigants, while a symptom of a broader problem, place burdens on the courts and on the opposing parties and work their own special forms of injustice. Our trial system is designed to operate on the adversary system, under which each party presents his case and the judge acts as impartial decision maker. An unrepresented litigant may not know how best to present his or her case. The judge may try to assist, but then this raises the possibility that the judge may be seen as helping or partial to one of the parties, namely the unrepresented litigant. So the proceedings are often delayed by this and stretched out, adding again to delays and the public cost of running the court. And it's not only unrepresented litigants who are prejudiced. Lawyers on the other side have told me that they find that the unrepresented litigant is asking them to help them against her own client. And what does the lawyer do then? Obviously says no, but when you have a quick question just before the judge comes on the bench, do I stand up now or what do I do and so on, it can sometimes be difficult to actually say no. And so these lawyers are telling me that they themselves are finding it difficult to operate in this system where they come to court fully prepared and backed by a client who is paying them, and find on the other side an unrepresented litigant may be raising all sorts of issues that have nothing to do with the case, may be asking for advice, and so on, all adding to the cost that perhaps their client will ultimately have to bear. A related barrier to access to justice is the problem of delay in the processing of cases. This problem afflicts both criminal and civil cases. On the criminal side, delays in proceedings may result in serious cases being stayed in extreme cases, since the Charter guarantees a trial within a reasonable time. Delays may also result in lengthy periods of incarceration for the accused person prior to trial. Even where the accused is out on bail, the stress of ongoing proceedings and the upcoming ever-deferred trial may be considerable, not only for the accused, but for his or her family. Victims are frustrated. They want justice, and further injured by the lack of closure. Witnesses are less likely to be reliable when testifying about events that may have transpired years before a trial. Not only is there erosion of the witness memories with the passage of time, but there is an increased risk that a witness may not be available. Sometimes witnesses get sick, or they die, or they move away. And as the delay increases, swift, predictable justice which is the most powerful deterrent of crime, becomes ever more elusive. The personal and social costs are incalculable. On the civil side, different but similar problems arise. Whether the litigation has to do with a business dispute or a family matter, people need prompt resolution so that they can get on with their lives. Often, they can't wait years for an answer. When delay becomes too great, the courts are no longer an option. So they look for alternatives or sometimes just give up on justice. A final barrier to access to justice is complex court proceedings. Court procedures and rules of evidence have developed over the years to ensure orderly and fair proceedings. But in many cases, complex court procedures, designed perhaps for the elite and most serious of cases, work an unfairness because they're simply too cumbersome, too complex for the case, which may contain just a simple factual dispute or not involve a great deal of money. If procedures are too complex, they cause delay, they drive up cost. And for a person without a lawyer, complex procedures may make it difficult to understand how to present his or her case. Court systems where some of the people ride in Cadillacs to justice and others walk or indeed may never get out of the gate just aren't acceptable. The reality that many people do not in fact have access to justice brings me to the second part of my remarks today. What are the solutions to this problem? How can we remove barriers to access to justice? How can we build on the many, many excellencies that are already there in our justice system and fill in the cracks and ensure that justice is more broadly available? Let me say immediately that the problem is complex and the solution will require a multi-pronged attack. Government must be a partner, the courts must be partners, and the legal profession must be partners. Each of these institutions must work with each other in consultation and in concert if we are to bridge the disconnect between the ideal of access to justice for everybody and the reality that too often justice can't be accessed. We're starting to see the beginnings of such an effort. Departments of Justice and Attorney Generals across the country are reviewing and revising court procedures, both criminal and civil, in an effort to reduce delay and cost. Courts and judges are seeking to improve access to justice by streamlining their procedures and promoting efficient and early dispute resolution. The bar is playing its role through pro bono services and other initiatives, such as unbundling of legal services, where a lawyer helps a litigant with specific aspects of their case. Thought is also being given to coverage for legal services within specified limits as an endorsement to some home insurance policies. I believe that a fundamental part of the solution to access to justice is a recognition of a principle called proportionality. By proportionality, I refer to the principle that the cost, complexity of procedures, and time required to resolve a dispute must be proportionate to what is at stake and the solution that is sought. While some cases may be so large and so complex that they require a longer and more complicated procedure, smaller, more straightforward disputes should have a simpler, more efficient, and cost-effective procedure. What people want and need is a fair and effective resolution of their disputes. This principle of proportionality, I think, must be taken into account in all court procedures. The resources devoted, costs incurred, and time spent must be proportionate to the issue. As Chief Justice Warren Winkler once said to a prolix lawyer who was objecting to Justice Winkler's suggestion that the length of the trial should be limited to a certain number of days, and arguing in support of this objection that his client was entitled to his day in court, Justice Winkler replied, "You can have your day in court, but not someone else's." That's proportionality. The principle of proportionality has animated recent efforts at reform of the civil justice system. In this province, the Civil Justice Reform Working Group, co-chaired by Chief Justice Donald Brenner of the British Columbia Supreme Court and Deputy Attorney General Alan Seckel, QC, has made important recommendations to improve access to justice and the efficiency of the civil justice system. They involve, for example, creating hubs or places where people who might be looking for legal advice can come and find it and be directed to a lawyer or other source of that advice. They involve requiring parties to personally attend case planning conferences in the early stages to map out how the process will work and perhaps shorten it or find ways to avoid useless efforts. And they involve limits on things such as discovery, motions, and so on. Now, all of these things are difficult and sometimes controversial to people who are convinced that they provide wonderful justice, as they often do. But the point is, they can become inappropriate or disproportionate, to go back to the ideal of proportionality, when applied across the board to all cases. Now, as we speak, the British Columbia Rules Committee is considering these various options and will shortly, I believe, recommend changes that will hopefully introduce greater efficiencies into the civil justice system in this province. Same thing is happening elsewhere in Canada. In Ontario, the Honourable Coulter Osborne provided a report a short time ago, and with the support and the help of the bar, it is now being implemented by changing rules and changing the way the courts and the civil side are doing their business. These basic measures are supplemented by other innovative and efficient dispute resolution procedures. We live in the 21st century. The world has changed in the last 10 years, the last 20 years, the last 100 years. And yet in many ways, our court systems have not kept up with those changes. So we need to look at our justice system and see whether sometimes small changes can reap big dividends in making our justice system better and more accessible. For example, in many provinces, including this one, the limits for accessing simple procedures in small claims courts, often without a lawyer at all, have been greatly increased or are being increased. In many provinces, alternate forums are being developed. For example, telephone trials to resolve disputes between landlords and tenants. Why not? In many provinces, video is being used to allow witnesses to testify from a distance and thereby cut down costs and delays. And indeed, people are talking, not in this country, but in some countries, about entire trials being conducted by video. Video is so powerful that the judge can actually see into the witness's eyes, obviating concerns about credibility, obviating concerns that the result will not be as good as if the trial were conducted in a courtroom. All of these things are available to us, and courts and court administrators are beginning to use them. Part of the solution is what we call ADR, alternate dispute resolution. Courts in all provinces have for some time now been promoting various forms of out-of-court mediation and arbitration. Some cases, a lot of cases, can be settled quickly, and that is all the parties want. And what we need then is to have means available for them to access trained mediators to facilitate them in these settlements. A few cases, and I firmly believe this, need to go to court. I think the court system is essential to the continuance and to the repute of the administration of justice. But let's face it, a lot of the disputes simply involve situations where people want to quickly and cheaply resolve their difference with their neighbor or with their professional or with the person who rear-ended them yesterday in a car accident and get on with their lives. Pro bono legal services are increasing as well. There's been a huge recognition in the legal profession in the last year or two of the value of pro bono services, not only to people who need legal services, but indeed to the legal profession itself. In many lawyers' practices now, we are seeing developing pro bono schemes, allowing lawyers, often young lawyers who want to take on a variety of cases, to work on a basis that is partly or perhaps not funded at all except for disbursements and such. And this is becoming more and more organized. As well, contingency fees, reduced fees, and other variations, flexible approaches to the problem are helping more litigants get help. Some firms treat time spent on pro bono legal services as indeed equivalent to billable hours from the point of view of the lawyer who may be seeking advancement in the firm. Some maintain committees to review and proactively seek out pro bono opportunities. All of this is good. A year or so ago, I was in the courthouse in British Columbia in Vancouver, and I was waiting at the door for a car. And there I saw a little piece of paper saying, "Do you need a lawyer?" And on the side were those simple little things, those little tear-off slips. And they had a lawyer's name on it. And what was being given was this. You could tear off a slip and you could get 1 hour with a lawyer. And maybe that would help you. Maybe it would lead to something else. But it was a beginning. It was a place where people could start to access justice. I won't take the time to describe at the broader Law Society level the various programs that are promoting pro bono services. But it's happening in BC, it's happening in Ontario, there's Pro Bono Alberta, Pro Bono Law Saskatchewan, and it's happening as well in other areas of the country. We have legal advice clinics. We have rule changes to allow for new ways of financing cases. And as I mentioned a moment ago, lawyers and law societies are now considering the possibility of permitting what are called in California unbundling of legal services. And this is what happens when you have an in-person litigant who says, I can take step A, I can take step B, I can take step C, but then I don't know what to do at step D. So unbundling would permit, and is being used in California to permit, that person to consult a lawyer simply for the purpose of that isolated step. Now, it raises problems in terms of conflicts. It raises problems in terms of the liability of the lawyer who may not have the whole picture or be able to follow through on the course. But it's something that is being looked at. Another device, which I mentioned a moment ago, is the creation of hubs. This has been an idea that's being pioneered in British Columbia. And the idea is that we have centers in our cities and in our towns where somebody who is looking for legal services can come to obtain at least some advice as to where he or she may start. This lawyer could provide you with 1 hour pro bono, for example, or you should be going to the rentalsman's office, or whatever the case may be. As Chief Justice of Canada, I chair the Canadian Judicial Council, and we have a responsibility for ensuring that the administration of justice is efficient and effective throughout the country. And we take this responsibility very seriously. So we too have developed an Access to Justice initiative. And in concert with people all across the country, judges and lawyers, we are working to develop new techniques, to do research, to act in myriad ways to further access to justice. Let me say a few words finally about the problem specifically of delay. I've already referred, incidentally, to delay. But here we have some real success stories. 10 years ago in Ontario, civil appeals were taking 2 to 3 years from what lawyers call the date of perfection. It may not be real perfection, but it's when the documents are completed for appeal and when they were heard. And criminal appeals were sometimes not much better. They were taking 1.5 to 2 years. A concerted effort was made to reduce this time, and today the time has been greatly reduced. Civil appeals in Ontario are now being heard within 12 months of perfection, and criminal appeals in 6 to 9 months. Similar steps are being taken with respect to reducing delays on complicated trials in the criminal justice system. One of the phenomena in recent decades has been the development of complex, long criminal prosecutions. There are many reasons for this. The Charter, I think, contributes by guaranteeing rights and contributing to the procedures and the motions which must be worked through in a complex criminal trial. But crime is more complex. Crime is often organized, and typically these complex trials arise out of that kind of a situation where you have multiple accused and a complex web of alleged criminal behavior. And these trials often they consume a great deal of time and a great deal of public resources. In Ontario, the Honourable Patrick Lesage and Professor Michael Code, at the behest of the Attorney General, recently prepared a report making recommendations to streamline procedures in large and complex criminal trials. The Ontario government put into place many of the report's recommendations immediately, and the report is not long out, such as assigning Crown attorneys to provide legal advice to the police at an early stage in order to focus investigations, and creating a mandatory system of peer review in complex prosecutions so that prosecutors make decisions in these cases with the advice of experienced colleagues and not alone. The Ontario Attorney General has also asked the Federal Minister of Justice to make changes to the Criminal Code, including increasing the power of pretrial judges to make binding rulings before the trial gets going so that the whole trial, including all the jurors, aren't held up for days and weeks while these motions are heard in the course of the trial, and changing the law regarding national security claims and issue in terrorism trials to avoid the delays caused by the current requirement that national security issues on appeal have to be considered by a judge of the federal court. So this involves references at the present time from the trial judge up to the federal court, then back down, so you can appreciate that this causes delay. Many of the recommendations of Justice Lesage and Professor Code could be applied nationally, and the Ontario Attorney General plans to pursue recommendations with his counterparts federally and in other provinces and territories. In short, it's important that efforts to improve access to justice address both the criminal and the civil system. The same courts hear civil and criminal matters in many cases, and so delays in one cause delays in the other. So we have to take a holistic view of this. It's important that we look at the civil side. It's important we look at the criminal side. But the final thing we have to do, let me suggest, is to look at how they interact with each other in the actual court system. Improving access to justice is a work in progress. It requires openness and innovation. Just because something has been done a certain way for a long time does not mean that it is necessarily the best way to do it now. The world is ever changing, and the justice system must adapt. It must continue to provide a place for people to come and have their cases resolved, the injustices corrected, the wounds healed. The late American judge Richard Arnold expressed in simple language the goal to which we aspire. He said this, and I quote, "We should think of courts, state or federal, as places where anyone can come and say, 'I am a human being. I am here. I have law. I think I do anyway. So judge my case.' Justice, the right to have one's case judged in a fair and timely manner, is a basic human right. We must all work together, the government, the courts, lawyers, and you, the public, to ensure access to justice. Only in this way will we remove barriers and clear the path to a just society. I look forward to your questions and to continuing this discussion. Thank you very much.
Chief Justice McLachlin, thank you for joining us tonight. Thank you for reminding us what Canada should and does stand for. Accessibility, it's such a beautiful word. It's such a lovely idea. So thank you for bringing your wisdom to bear on the challenges we still face. And I think reminding us that sometimes small changes can make large changes in the system.